Welcome to this instalment of the Field Fisher video blog on the legal implications of Brexit, following the UK's final departure from the EU on the 1st of January 2021. My name is Nick Pimlott. I'm a partner in Field Fisher's regulatory group, and I'm going to give you a brief overview of the implications of Brexit for public procurement. Before diving into the intricacies of procurement post-Brexit, I want to start with some basics. What is public procurement? Well, public procurement is the purchase by government of goods, services, or construction works from the private sector. Purchases may range from everyday office supplies to highly complex outsourcing or infrastructure projects. And public procurement represents a very large segment of the economy. The UK government spends around £284 billion per year on purchasing goods, services and works from the private sector. Across the EU, this increases to around €2 trillion per year, or around 14% of GDP. Within the EU, the opening up of government procurement to suppliers from other member states has long been seen as an important driver of the single market, fostering the integration of European economies. Opening up government procurement also has other benefits. It gives governments access to a wider pool of goods and services and helps to ensure value for money. It's also an important bulwark against corruption and cronyism. So, for many years, the EU has had a system of rules governing public procurement built around the EU-wide advertisement of proposed public contracts above a certain size, together with open and competitive tendering following the principles of non-discrimination on national grounds, equal treatment, transparency and objectivity. The most recent incarnation of these rules is in a series of directives that were last substantially updated in 2014 and are implemented, so far as the UK is concerned, in a number of regulations. The Public Contracts Regulations 2015, the Utilities Contracts Regulations 2016, the Concession Contracts Regulations 2016, and the Defence and Security Public Contracts Regulations 2011, all in the case of England and Wales, with equivalent regulations in Scotland and Northern Ireland. The EU procurement rules do not govern what is purchased by government, nor do they require governments to competitively tender for goods and services they can provide for themselves. They govern the process by which contracts are awarded by governments to the private sector. Against this background, the rules in the UK governing public procurement have, prior to Brexit, been very heavily based on the EU rules. In fact, stripping away the EU rules, domestic law in the UK has had relatively little say about public contracting. Traditionally, domestic courts have treated decisions by public bodies to award contracts as essentially commercial in nature and beyond the scope of judicial review of administrative decision-making. Although that traditional view may have shifted slightly in recent years, the fact remains that absent the EU rules, there would be very limited legal oversight of public procurement under purely UK domestic law. The EU procurement rules are not, of course, without their critics. They are seen by some as overly complex, bureaucratic, and costly to comply with, as well as liable to hinder pragmatic commercial decision-making. When negotiating the current set of directives in Brussels in 2014, the UK government set out with the explicit aim of making the EU procurement rules more flexible in a number of specific respects, and in large measure achieved that objective. But the directives, and consequently the domestic regulations, remain lengthy and complex. And the inevitable fact is that whatever the specific rules laid down in directives or regulations, running a fair and transparent procurement process is a demanding task for public bodies that can easily go wrong. And when things do go wrong, the EU rules require that bidders who risk suffering harm as a result of a breach of the rules can seek redress by having the award decision set aside or seeking damages. Litigation over procurement decisions is consequently a familiar part of the procurement landscape for authorities and bidders. And so to Brexit. What will change? What will stay the same? And what is coming down the line? First of all, some legal mechanics. At 11 p.m. on the 31st of December 2020, the transition period established in the EU-UK withdrawal agreement of 2020 came to an end. During the transition, the UK was outside the EU but still formally bound to comply with EU law. So little substantive change to the law, including in the area of procurement, was visible in the UK. At the end of the transition, the European Union Withdrawal Act 2018 came into full force and effect, along with the new UK-EU Trade and Cooperation Agreement. In addition, and importantly from the perspective of public procurement, the UK acceded in its own right to the Government Procurement Agreement of the WTO, which I will explain in more detail shortly. The EU Withdrawal Act 2018 repealed the European Communities Act 1972, which was the foundation for both the direct application of EU law in the UK and the making of regulations to implement EU directives, such as the regulations on public procurement. To avoid a legal vacuum, the 2018 Act imported the entirety of EU law as it stood on the 31st of December 2020 into domestic law, as well as providing a new legal basis for regulations that had been made to implement EU law, collectively referred to as retained EU law. So the regulations governing procurement, such as the Public Contracts Regulations 2015, as well as the general principles of EU law and the case law of the European courts in the area of procurement, were preserved as of 1st of January 2021 by the 2018 Act. At the same time, since EU law is peppered with references to EU institutions, procedures and principles that are no longer relevant within the UK post-Brexit, the 2018 Act empowers ministers to make regulations amending or correcting retained EU law to make it function properly in a purely domestic environment. In the case of public procurement, we have the Public Procurement Amendment, etc. EU Exit Regulations 2020. Those regulations tidy up the domestic regulations on procurement. They remove, for example, no longer relevant references to the European Commission, which is usually replaced by the Secretary of State, to cross-border procurement, or to EU-specific tools such as the European Single Procurement Document. Mostly these are mere technical changes with little practical impact on the practice of procurement. The one significant practical change is that UK authorities are no longer able to publish notices in the official journal of the EU. So obligations to publish in the OJEU are replaced with obligations to publish in the UK e-notification service, which has been established by the Cabinet Office under the name Find Tender Service. So the immediate consequence of Brexit on the day-to-day practice of procurement in the UK is little change in the short term, although divergence may happen in the future. And what of the future? And importantly, what about the position of suppliers from the EU who wish to bid for public contracts in the UK, and conversely, UK suppliers who wish to bid in the EU? As I have already mentioned, simultaneously with the end of the transition, the UK acceded in its own right to the Government Procurement Agreement of the WTO, or GPA for short. The GPA, in world trade jargon, is a plurilateral agreement within the framework of the WTO. What does that mean? It means an agreement to which not all members of the WTO are party, only those who wish to sign up. The aim of the GPA is to mutually open government procurement markets among its parties. There are currently 21 parties to the GPA, comprising 48 WTO members. The EU is a party to the GPA and signs up on behalf of all the member states of the EU, who are then in turn obliged to comply with the EU's commitments under the GPA regarding non-discriminatory access to public procurement for operators from other GPA states. In addition to the EU, GPA states include US, Canada, Australia, Japan, and other essentially advanced economies, plus a handful of other smaller countries. Pre-Brexit, the UK was a member of the GPA via its EU membership. Post-Brexit, the UK has acceded to the GPA in its own right, and accordingly has made commitments regarding non-discriminatory access to public procurement in the UK to economic operators from other GPA states. Similarly, UK economic operators will continue to have access to public procurement markets in GPA states on a similar basis to the pre-Brexit position. The UK's accession to the GPA is a significant development in the post-Brexit procurement landscape. Although essentially a voluntary act, the UK could in theory withdraw from the GPA at any time if policy changed. The GPA restores some of the underpinning of international law that was lost when the UK left the EU. It means that, at least for the foreseeable future, there is unlikely to be a major departure from the core principles of public procurement that are familiar under EU law: open and competitive tendering for contracts above a certain value, non-discrimination, equal treatment, transparency and objectivity. Whilst the GPA is built on similar principles to the EU procurement rules, it is much less prescriptive in terms of the procedures that may be followed than the EU rules. The GPA also gives the government scope to revisit the EU rules on remedies where there has been a breach, potentially watering down the remedies available to unsuccessful bidders. The government has recently published a green paper entitled Transforming Public Procurement, in which it is consulting on proposals to reform the procurement rules in the light of the new flexibility afforded by the GPA. The GPA is also more limited than the EU rules in terms of coverage. Whilst the EU procurement rules open up procurement markets for all goods and services, including those in sensitive sectors such as health and social care, the GPA covers all goods and a more limited category of services corresponding to those which are considered suitable to be opened up to international competition, such as computer and related services, banking and financial services, consultancy services, etc. Health, social care, education, and so on are not covered, nor is military or defence procurement. Finally, what of the EU-UK Trade and Cooperation Agreement, or TCA, Boris Johnson's much vaunted Christmas Eve deal? The TCA contains provisions on public procurement which essentially incorporate and expand on the parties' commitments in the GPA. Under the TCA, the UK and EU agreed to extend market access to procurement by utilities engaged in the provision or operation of gas or heat distribution networks, as well as to a range of additional services not covered by the party schedules to the GPA, such as hospitality, telecoms, real estate, education and other business sectors. Health services, however, are expressly excluded. So in many sectors of the economy, for UK suppliers looking to sell into the EU and vice versa, the UK's accession to the GPA in combination with the TCA means that little fundamental change is expected in access to public procurement market. If nothing else, Brexit is a legal revolution for the UK. In a world where importers and exporters are struggling with customs declarations and rules of origin, where UK businesses are having to set up in the EU to retain access to EU-based customers, and where British lorry drivers are having their sandwiches impounded, it is perhaps surprising to discover that public procurement law, sometime bugbear of the pro-Brexit tendency, emerges unscathed in many respects. Undoubtedly, there will be changes resulting from the current Green Paper, and there is the possibility for future divergence from the EU rules. Some of those changes, like simplification of the procedural rules, may be welcome to both bidders and authorities. Others, such as the watering down of remedies, if that is pursued, may be less so. But the essential features of the EU system of open and competitive tendering for government contracts above a certain value, non-discrimination, equal treatment, transparency and objectivity, backed by a system of remedies when things go wrong, seems likely to be with us for the foreseeable future.